All right, good morning, good afternoon, good evening, depending on when you're seeing this video. This is Prof TV. And of course, we have been doing a little bit on contract since just recently. And right now, we are still in the elements of contract. Of course, I told you it is a loaded topic. We've done offer. Now we are supposed to be doing acceptance. Now, if you've not watched the video on offer, I urge you please go back and watch the video on offer, so that because we'll be building on it in order to understand acceptance. Because of course you know that there is nothing you can accept if there is no offer that is being placed before you. And so in order to understand acceptance, I think you must be able to have a grasp of offer. Now, acceptance. We'll be defining acceptance according to Itesage. And we have been, I think we have been quoting Itesage in definition lately since I started this contract. Why? Because I like his book. This is his book I use and all that. So acceptance, according to Itesage, is the final and unqualified as expression of assent to the terms of an offer. Acceptance is the final and unqualified expression of assent to the terms of an offer. So, when an offer is being presented, your final and unqualified assent, when we mean unqualified, we mean you did not add any other thing. It is that particular offer that is being presented that you are accepting. That is unqualified. And when we talk about final, we are saying that you cannot come out from it again. It's just like court. If you enter, you have entered. Unless if you are coming out from it, okay, we will still look at the revocation and repudiation or vitiation factors and vitiation elements and all that. But be that as it may, ordinarily, when you enter into the contract and you give your final expression of assent, it means that the contract has been sealed. That is the definition of acceptance. Final and unqualified expression of assent to the terms of an offer without adding anything. They say you buy this marker for 100 naira, you agree, yes, I'll buy this marker for 100 naira. That is acceptance. But as we can see, or as we will see, when you now put your own amendment to the offer, you will see what it will become. For example, I say I want to buy this thing for 100 naira, and say no, I'll buy it for 70 naira. We do it every time in the market. Hey, this thing is good though, I want to buy it. They say 5,000. Say, you will not say 2,000. So I say, okay, bring 4,000. See, last price, I have 3,000. Or I put 3,500. You know, all those things, nobody has accepted anything yet. You have just been counter offering. When one person will now agree and say, okay, no problem, let me buy it for this amount that you've offered, then acceptance has taken place. Now, in the case of Bilante International Limited against Orient Bank Nigerian PLC, this case is very, very, very important. Very, 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 very important. I urge you to read this case if you want to understand offer and acceptance. This case is very, very, very important. You must have to read this case if you want to understand offer and acceptance. And I'm talking to my students, like talking to 200 level students, law faculty, all over the world. Okay, even though this is a Nigerian case, but then yes, if we read English cases, why won't English people read our own cases? Okay, so in Toby JCA, in Bilante International Limited against Orient Bank Nigeria PLC, Nikki Toby JCA, as he then was, stated that acceptance can manifest itself either by words, acceptance by words, by conduct, or by exchange of documents between the parties. So we see that normally the one we know is acceptance by words. Please, this is what I want. Okay, no problem, I will do it. Acceptance by words. I have accepted, and you know that I have accepted. Oral contract. Remember, we are building on what we have done in the first video of law of contract, that we did classification of contract, we did express and implied, we did express and implied, we did bilateral and unilateral, and we did formal and simple. So if you don't understand express, implied, if you don't understand unilateral and bilateral, if you don't understand formal and simple contracts, then this video is not for you. Go back and watch the introduction to law of contract and get a grasp of what we are talking about. So acceptance by words, you have said it, okay, okay, no problem, I'll do it. Acceptance by conduct is based on the performance of that particular thing they have offered to you. So they offer you something, and instead of just using your words to say, okay, I will do it, you actually go ahead to do it. So it is still seen as acceptance. Then acceptance by exchange of documents. Of course, when you are talking about express contracts, yeah, where the terms of the contracts are clearly spelled out, and you would have to, sign and exchange the document. That is an expression of assent or acceptance. So when we do contract of sale of land, we see that one of the procedures for contract of sale of land, one of the things that you must do is the exchange of contract, which of course is an acceptance by exchange of documents. Acceptance by words, acceptance by conduct, and acceptance by the exchange of documents. That is according to Nikitobi JCA in the case of Bilante International Limited against Orient Bank Nigerian PLC. If you even look at that case, you will still see the definition of Nikitobi, his definition of acceptance. And even though his definition is very wild, I can't really say it because it's written in the book, in It's against book. It's too long. So I want something that will be very brief for you to understand. But if you still read the case, you will still see the um, definition he proffered for acceptance. Now, having understood the meaning of acceptance, let us try to delve deeper and to know the invalid form of acceptance. There are some things that you will see and you will think is acceptance, but it is not acceptance. There are some things that look like acceptance that is not really acceptance. And now we go into it so that when it happens, you will not say that this is an acceptance. That, and you know, of course, that acceptance being a final unqualified expression of assent means that once acceptance has taken place, and of course consideration follows, the contract is sealed. Nobody can come out of it again unless with unless you want to suffer some kind of liability. So it is important to know the invalid form of acceptance. So you will know that, okay, when this person does this and he thinks it's this acceptance is doing, it is not actually acceptance that he's doing. So we'll take a look at it. All right. So invalid forms of acceptance. Now, when you look at most of these forms of acceptance, it's not even call it a form of acceptance. These are invalid form of acceptance. So one, just take it immediately. Counter offer. What is counter offer? Now, remember that these things are what looks like an acceptance of a contract, but is not actually an acceptance of a contract. So it is the invalid form of acceptance. So you cannot come and say that because you've done any of this, that you have accepted a contract. Remember, you might see a scenario that will paint most of these topics, and they will ask you, advise the parties on whether or not there's a contract between them, or advise the parties on the validity of the acceptance, or advise the parties on the liability, if any, that the breach of contract would cause. Of course, you know that they know that there is no breach of contract. In fact, there is no contract, so there cannot be any breach of contract if these kinds of acceptance are in place. So we'll just explain them so that you would know how to apply it to a scenario. Now, if you're in 200 level law faculty and you're watching this, you would know that your exam questions are usually scenario based, even though we also have essay based questions. So your ability to understand most of these principles and apply it to a scenario will guarantee your success as a law student or as a lawyer generally, because that's what lawyers do. They will see, they apply the law to life matters, and that is how they train you from university, so that you'll be able to know what the law says, and not only know what the law says, know how to apply it to life matters. Now, counter offer. What is counter offer? Counter offer is just like the example I gave. You are offering, and instead of accepting that offer, you are offering your own back. So if I say this, and you remember I said that acceptance of offer is accepting the offer as it is, accepting the offer as it has come, unqualified. You are not supposed to put your own. So when you say counter offer, you're saying that that particular offer that has been made to you, you have made another offer that is different, even if it is slightly different from the one that was made to you. Please, I am selling this marker for 100 naira. Buy this marker for 100 naira. I am offering it to you. You will say, no, I will buy the marker for 70 naira. I will buy the marker for 70 naira. Now, the person that says I will buy the marker for 70 naira has counter offered the offer that says buy this marker for 100 naira. And one of the effects of counter offer is that as long as that person that has counter offered, that 70 naira person has counter offered, it has automatically eliminated the offer of 100 naira, the initial offer of 100 naira. This means that you cannot, after counter offering that 70 naira, say I will buy 70 naira, you will now come back to accept that 100 naira offer. So this would play out in such a way that if I say buy this for 100 naira and you say no, I will buy it for 70 naira, I did not accept your offer for buying it for 70 naira. Another person comes and I sell to another person for 100 naira. You cannot sue me telling me that you have accepted, but that you accepted on different terms. No. What you did was counter offer, and I also have the powers to say, okay, when you now come after telling me that you want to buy for 70 naira and I refuse, you say, okay, give me for 100 naira. I can say no, I am not. The offer is not open again. If you sue me, the court will say that the offer had died when you counter offered that initial offer. So the effect of counter offer is that it automatically eliminates the initial offer. So they might paint it in a scenario like this. Mr. A has offered Mr. B this. Mr. B counter offered, or maybe re-offered. They might not use counter offer so that you don't know what they want you to do, because these lecturers are usually very wicked. So they will now say, they might not ask you, what is now the validity of accepting the initial offer? You see, keep simply tell them that when there is a presence of counter offer, that the initial offer has been eliminated. And imagine I now counter offer again, the counter offer that was made, that other counter, as far as the last offer eliminates the initial offer. So counter offering is an invalid form of acceptance. So that somebody will not counter offer and you will now think that the person has accepted. So that is invalid form of acceptance. A contract has not existed between you if the counter, if somebody, instead of accepting, counter offers. So it is now left for the person that made the initial offer to accept the counter offer for the contract to be bettered. One of the elements of contract is acceptance. And until there is an acceptance of an offer, contract cannot be said to have been given birth to. Don't really understand what I say. So counter offer is just different offers. There must be an acceptance for the contract to be sealed. So if you counter offer, you cannot take that as an acceptance. And that is why it's an invalid form of acceptance. Because people might think that counter offering is also a kind of acceptance, but maybe you accepted on different terms. So I'm here to tell you that counter offer is not a form of acceptance. What about cross offer? Cross offer is not like counter offer. Remember that counter offer is supposed to reach to the offeree. The offerer is supposed to make the counter offer to the offeree. Sorry, the offer to the offeree. Then the offeree will now make the counter offer to the offeror, making the offeror now the offeree. So it is now for the initial offeror, who has now turned to the offeree by virtue of the counter offer, to accept the counter offer for a contract to come into place. Now, in cross offer, a cross offer is usually seen when you are sending the offer by writing, by post. So let's say you offer the same term. So you offer to buy my marker for 100 naira by writing to me. You put it in a post and it's coming. And I am offering for you to buy my marker for 100 naira too. And I put it in a post. And the two of them, the post office or something, it crosses. And I receive your offer and you receive my own offer. Of course, you will say, since it's the same term, the contract has started existing. But the law says no. Contract must be made up of offer and acceptance. What had happened was just cross offers. So even if you people had the same terms, saying okay, since it's the same term, that means the contract has started. The law says one person must accept. So cross offer is not a type of acceptance. You don't take it as, even though two of you are in consensus ad idem, this is what you want, this is what the same person, the person you're offering also is offering you the same thing. This is what you're also offering your the offering. The two of you are offering and offering together because the offer crossed. So it is left for one person to have accepted it and say, okay, I accept this offer, even though I had sent an offer before that crossed. So that is crossover and it's an invalid form of acceptance. So you cannot look at it as an acceptance. Acceptance and ignorance of an offer. So acceptance and ignorance of an offer cannot even stand because what are you accepting? Let us even assume that an offer is subsisting, an offer is in existence, but you don't know that that offer is in existence, and you accepted, not like you accepted, maybe you did that stuff, you acted not knowing that that action you did was a form of an acceptance of an offer that was in existence. It cannot be said that you have accepted that offer. But for you to accept an offer, you must know that the offer is in existence. You must be accepting that offer. Unqualified and final expression of assent to the terms of an offer. So if you are not expressing your unqualified assent to a particular term of an offer or to a particular offer, then what are you accepting? A contract must be made up of an offer and acceptance. So if you don't know about an offer, then you cannot be said to have accepted the offer. Now, most of this acceptance and ignorance of an offer is usually seen in reward cases. And reward contracts, when I'm looking for my dog, I say, anybody that finds my dog, I'll give the person $5,000. What kind of contract is that? You see, you don't know because you have not watched that other video that I did, introduction to contract. It is unilateral contract. Now, imagine there is an offer that somebody is looking for the dog, and that if you see the dog, they will give you $5,000. Now, they have not really published that advertisement. You brought the dog back to the person by 2. And of course, they've already given it to the radio, and the radio people will have to play it by 4. So you've already brought the dog back by 2, and the radio people now play because, of course, you have given the radio, they have paid the radio, and the radio, there's no how to withdraw it that day from the radio so that the advertisement will not go on air. And the advertisement went on air by 4. And you heard it. And you're now coming back to say, okay, I brought the dog back by 2, and I've heard by 4 that there is an offer that please give me my money, my $5,000. The law says it's a lie, that you cannot accept an offer that you are ignorant of. So that is an invalid form of acceptance. Invalid form of acceptance. So acceptance subject to contract. Now, when you talk about subject to contract in a particular contract, it means that particular negotiation or that particular contract is really not a contract. Okay, let me not be calling it a contract. That particular negotiation or that particular agreement is good. If it is written subject to contract, it is not yet binding until a formal contract has been drawn up or until an express contract has been documented or written and the two of them will sign. So you can be having some kind of negotiations with people, with some your partners in business and all that. and the negotiation is embedded in an agreement. And after because the agreement is still going so many undergoing so many reviews, you now put the agreement subject to contract, so that nothing in the agreement will be binding on the two of you until a formal contract has been drawn up or has been prepared and signed by both parties. So anywhere you see subject to contract, it is not yet binding until a contract, an actual contract has that the two of them agree has come into place. So when you now see that particular agreement and you now think that because you have accepted most of the terms in the agreement that it should be binding, you are joking. Because subject to contract will remove liability or will postpone liability until the contract has come into force and both parties have signed. Now, acceptance of tenders. Now, I usually explain tenders by way of the fact that government or contractors would be looking for a very good supplier of something, or maybe the government wants to build road and they are looking for a very excellent engineering contractor or engineering company that would build the road for them, and it will be very nice. Now, they will now advertise tenders. All the engineering companies that think that they met the requirement in the advertisement would apply. Now, the government can accept the tenders, but remember that for example, if it is road they want to build, road, and the government accepts the tender of a particular engineering company to build the road, they have to wait for a formal contract so that they will now come into terms of the contract of how to build the road. If you accept tender, if the government accept tender, for example, and the engineering company starts immediately building the road, they are building the road on their own, nothing join the government. So acceptance of tender is not acceptance of a contract unless it is in the tender, the terms of the contract. Maybe in the tender they will now say the person that will be choosing for this thing should immediately start work or should immediately um, um, supply 50 bags of cement. If it is cement suppliers they are looking for, once you are chosen, immediately supply 50 bags of cement to a project that they are doing at this particular price. So for you to bid, of course, it is taking that impliedly you've read the terms of the particular offer. So you now know that even though the tender is being issued and you are bidding for tender, you have impliedly accepted that particular offer that came with the tender. So I'm not talking about that. I'm saying they are bringing tender, say this road they want to build it or want suppliers, and you bid and they choose you. They have accepted your tender, but you have to wait for some kind of contract terms that you will sign. So if you accept tender, if the government accepts your tender or any contractor accepts your tender, and you immediately start doing the thing that you think is what they want, then you're on your own. So acceptance of tender is not acceptance of contract unless a contract is accompanying the advertisement for tender. So that is invalid form of acceptance. So please, if you have any question, I will be waiting for you in the comment section. And thank you very much. Please do well to like and subscribe. And peace.